Good morning. Is everyone on board?
Good morning, ma'am.
Good morning, Ms. Williams. I see you here. I see Ms. Fantona is on. Ms. Fantona, can we see your face?
Morning, Judge. Can you see me?
Good morning. Right. Ms. Williams, I take it that you are on board on behalf of the applicant.
That is correct, Justice Naidu, together with Ms. Adhikari, who appears with me as my junior.
Ms. Adhikari, is that? She's with you?
Yes, Mushada Adhikari. She's in the meeting. She's just not on screen.
Yes. Okay.
She is now.
Okay. I still don't see her.
I see her on screen.
I can see Ms. Fantona, unless Ms. Adhikari is using Ms. Fantona's.
Judge, change your setting to show all
the connection is very bad. I can barely hear you.
You must change your setting to all participants, and then you can view everybody.
Okay. I'm just trying to find that. Show participants. Okay. Well, I can't see them, but I can see that they're on. Ms. Adhikari is also on. I can see that they have, but it's not serious because Ms. Williams, you will be conducting the hearing, not so.
That's correct, my lady.
Mm-hmm. I say you will be doing the presentation, or you'll be presenting the argument today.
That's correct.
Okay. All right. I take it there's no appearance for any of the respondents, or is there?
Not as far as I'm aware.
Good morning, Judge. My name is Esma Sina for Sam, and I should be appearing on the screen there.
Yes.
I am from the Office of the Attorneys for the 7th respondent, and my counsel should be joining us, if not yet, Advocate Sunday Okun Ronbi. Maybe he's running somewhat late, I don't know, but I should be expecting him. I communicated with him this morning. Thank you, Judge.
So he hasn't arrived yet then, or he has not joined yet, let's put it that way.
Yeah, I don't know what's going on, but let me quickly try to find out, call him, see if you could indulge me for a couple of seconds.
Yes, certainly.
Thank you kindly. Thank you. Do you have his number? It doesn't seem to be here. Is it ringing? You're calling him?
I'm calling him. Yeah, he's online.
Yeah.
Hello, Sunday.
Yeah.
Same here. Everybody's online, have already joined, and
Okay.
you're trying to join.
I tried. I don't know what I did. Okay, I've seen Miss Basidito's email. Let me try this one now. Okay, now it's getting me in. Yeah, thank you.
Is it getting you in there?
Yes, well, it's
Oh
it's
yes, so
very
I can
patchy.
see you've already joined. Thank you. Let's just switch it off. Thank you, Judge, for the indulgence. I appreciate it.
Okay, good. Has he joined us now?
Yeah. Good morning, Judge. My apologies for the technical glitch in joining late.
Okay, sorry, it's Mr.
Ogunrombi. Ogunrombi, my lady, is spelled Ogunronbi.
Okay, and you are, I understand, for the 7th respondent.
I am for the 7th and also the 8th defendants in this matter, my lady.
Okay. Well, the defendants, yes. Yeah. Right. Well, then let's kick off, Ms. Williams.
Thank you, my
Well,
lady.
before we go, I'm not sure what exactly is your purpose today, Mr. Ogunrobi?
Lady, I do understand there is an application for default judgment.
Yes.
And of course, the defendants have got an interest in the proceedings before the court, hence my appearance today.
Okay, so are you going to address me at all?
I intend to address the lady.
Ms. Williams, what is your attitude?
I have a difficulty with the presence of the 7th counsel for the 7th and 8th respondents and the attorney. And this goes back to the pre-trial meeting that we held on the 12th of September. The court would have noted the minute. A very clear timetable was set for the hearing of the default judgment today. Mr. Advocate Ogunrobi and the instructing attorney were given an opportunity to bring an application for the upliftment of bar. That did not happen. So to all intents and purposes, this default judgment is unopposed. Secondly, minutes before the matter was due to commence this morning at 9:53, I received an exception, I think from the 8th respondent, running to some 28 pages. That too is unacceptable because they've effectively been barred from pleading in terms of Rule 13.3.
Sorry, you keep freezing up, Ms. Williams. You said it's unacceptable because, and then you froze up there.
Sorry, I said that at 7 minutes
Sorry,
before
Ms.
10.
I'm sorry. Can I just ask that the counsels and attorneys switch off their cameras? Those are not addressing the judge, so that it can help with the connection and everything.
Thank you kindly.
Thank you.
Thanks.
Yes, there we go. Thank you, Ms. Williams.
All right. The point that I made is at 7 minutes to 10 this morning, when I joined this meeting, an exception came through, I think from the 8th respondent, running to some, I think, 28 pages. I obviously haven't had a chance.
Give me one moment. Give me one moment. I just want to record this. Did you say that was from the 7th or the 8th respondent?
I think it was from the 8th respondent.
And of course, your complaint is that that is irregular.
It's completely irregular because they've already been barred.
Yes, and what you're saying is that I shouldn't give them a hearing today.
That's correct, my lady.
You've frozen up again, Ms. Williams.
That's correct, Justice Naidu. We're saying that the matter should proceed on an unopposed basis, which is what this matter is, and that the 7th and 8th respondents' legal representatives should not be given a hearing today. They were given every opportunity to be before court today with a timetable set for the lifting of the bar. They just never took that opportunity.
That's very, very bad. I can barely, every 3-4 words you're freezing up. The connection is really poor this morning. I don't know whether it's on this side or on the other side, but you keep freezing up. You say that the 8th respondent should not be given a hearing, and I missed the rest.
I said that they've been given every opportunity to uplift the bar when the matter came before court on 12 September. They didn't avail themselves of this opportunity. What we now see happening is clearly a delaying tactic.
Can't
to
hear
try-
you.
Can I ask Advocate Adhikari to disconnect from this meeting? She's in the same room as me.
Can she not move to maybe another room? Might help.
I think it's probably easier if she just disconnects and listens. We share one computer.
Oh dear.
All right. But Justice Naidu, the point that I was making is that when this matter came on for hearing at the pre-trial meeting on 12 September, Advocate Argan Ruby and his attorney, 7th and 8th respondents' attorneys.
Paul, the connection is really bad. I'm not sure what's going on, but Ms. Williams keeps freezing up every 2, 3, 4 words. I'm not sure. Is it possibly on my side? Because I seem to have fairly good signal here. I'm not sure if it's on my side.
Okay, my lady, I think Judge, you should disconnect and connect again, because I can hear Advocate Williams very well.
Okay.
Yes.
All right. Let me try again. I'll disconnect and then I'll just rejoin.
Yes, thank you.
Okay. Ms. Williams, I can see you again. Let's hope I can hear you as clearly.
I hope so, Judge. Just to go back to the 12th of September's meeting, at that stage, the 7th and 8th respondents had already been barred, because in terms of the rules, the bar is automatic if you didn't file your plea timeously. They were then given an opportunity to uplift the bar. They didn't take that opportunity, and the presence today, coupled with the filing of a 28-page document minutes before this hearing was due to commence, were clearly designed to derail the hearing today, and the SIU's submission is that they should not be permitted to do so. So it's against that backdrop that I would...
You keep freezing up. I'm sorry. I heard SIU's attitude or...
The SIU submits that against that backdrop, they should not be entertained today, and the default judgment application should proceed.
Thank you.
Thank you, milady.
All right, Mr. Ogunrobi, I'm going to, just for the sake of professional courtesy and so that we can hear you, I'm sure you realize this is highly irregular. It's not in terms of the rules, and there's nothing that obliges this tribunal to actually hear you, because there's not even an application for condemnation. And I want to hear why your opponents were not given the courtesy of being telephoned at least, even if it's the weekend, just to alert them that this was going to happen. This is not how litigation is conducted. Maybe you can tell me what's going on.
Melody, I'm indebted for the opportunity to address the tribunal, of course. Indeed, I would have been in another court today, but for discussions and consultations I had yesterday and the resolution. So it's not as if I came to hijack the process of the court. Melody, the critical factors with respect...
Yes, but what I'm saying is this matter was set down back already. And in fact, months ago. So, the respondents were more than well aware and had more than sufficient opportunity. Now, at our number 99, you file documents. What opportunity does the tribunal have? Well, I haven't even seen it yet. And what opportunity would, excuse me, your opponent have to read and prepare? This is simply not how litigation is conducted.
Milady, I am not attempting to derail.
I'm sorry, you keep freezing up. I can't hear you at all.
Milady, this is not an application before you to arrest a default judgment from being granted or to stop the processes. I mean, I do not perhaps intend to even address the tribunal on the default judgment if the tribunal
You're freezing up, Mr. Ogunrombi.
Milady, I don't know what happens if my video is not showing, if it's better.
Well, I can hear you, but I can't see you, but I can hear you clearly now.
Yeah. Milady, my first point is that my appearance this morning is not to dissuade the tribunal from proceeding to considering the default judgment. I have not filed or appeared to attend to the default judgment itself. I've appeared as a matter of courtesy to the court.
Frozen up again. You say you're not attempting to stop the hearing of the default judgment. Am I hearing you correctly?
Correct, milady.
Mm-hmm.
Nonetheless, I intend to inform the court that exception has been filed this morning or will be filed with the tribunal.
I can't hear you. I'm sorry. A bad connection. I didn't hear the second part. You said nevertheless, and then I didn't hear you.
Nevertheless, to inform the tribunal that an exception has been filed or will be filed appropriately today, and the tribunal may want to consider that in terms of the rules of the tribunal.
No, sorry, I didn't even hear that. You say you just wanted to inform the tribunal that an exception has been filed and
to the extent that the exception is not covered by the same rules of the tribunal as plea.
Paul, this is going to be extremely difficult. I can barely hear him. Every 2 words, Mr. Ogunrombi is freezing up.
Okay.
I'm not sure. Yes.
Perhaps.
I'm not sure, Judge, because Mr. Ogunrombi is also.
I don't know what the problem is. I'm not even on the courts. I'm in the court building today. I'm not even on their system. I'm using my own router. So I would have imagined, and that's what I've been using throughout this month. Yeah, now it says it's connected, and I don't know. Let me rather just log off for
and reconnect.
Yeah, I'm just going to see if I connect to the system here, whether that will be better. I'm just going to call the IT person in quickly. I'm going to just log off for a few minutes. Okay.
Let's go places from there.
No, I was just thinking you need because when you move around, we can hear you when you're sitting.
Okay, I'm back on. I've just joined or connected to the Wi-Fi here in our building, and I'm hoping that it's a little bit more stable. Mr. Ogunrubi, can you hear me?
Yes, my lady, I certainly can. Thank you. I'm indebted. My lady, the first point that I wish to make is I am appearing not to stop the default judgment from being considered.
Yes.
At the same time, considering the discussions I've had with my attorneys.
No, you're still freezing up, unfortunately. I've asked for one of the IT people to come in. There you go. Our IT gentleman has just arrived. I've connected to the OCJ judges, but it just, you see, no, it's gone back to that. Yeah, thank you. Mr. Gondrumbi, can you hear me?
My lady, I can hear. I can hear.
I'm just going to ask our IT person to just hang on for a few minutes to remain present, but just to see if we have the same problem. He's connected me to the internal system. I'm so sorry about this, but I don't know where the problem is. All right, yeah. You say that you just wanted to alert the tribunal that an exception has been filed and?
And in that exception, I do believe that I should draw the tribunal's attention to the rules. The rules of the tribunal makes a distinction between a plea and other pleadings. This exception constitutes other pleadings, and in that instance, there is no bar in respect of the filing of this exception in terms of the rules of the tribunal. I think the 13.7.
Sorry, what are you talking about? Which rule?
Sorry, I just want to quickly refer the tribunal to the rules. In terms of Rule 13.7 of the rules of the tribunal, there is a distinction between pleading being filed within certain time and other pleading, which is dealt with in Rule 13.7. So we do not need condonation for the filing of a exception in terms of Rule 13.7 of the tribunal's rule.
But you have not pleaded, have you?
We do not need to plead to file an exception, my lady. An exception is an order pleading, which is not required to be filed with, before, or it's separate from a plea. And to accept to a plea basically speaks to whether even a cause of action is there. I will not be filing a plea if I need to file an exception.
Yes.
I mean, lady, the issues raised in an exception goes to the rules of the jurisdiction, the basis for this action itself. So it does not seek to engage with the facts of whether the court should even, if no cause of action is established, if, for instance, this tribunal has no power to set aside the decision of an arbitration tribunal and all those kind of issues, it's for the tribunal to decide what the tribunal wishes to do with the exception, but they are not issues on merit. And that's why I said I need to bring that to the attention of the tribunal. That.
All right, let me just try and reconcile what you're saying. You're saying that you don't want to stop the default judgment proceedings, but on the other hand, you're raising an exception, I imagine, to the summons.
Yes.
So what do you envisage will happen today?
before the, I do not want to argue the default judgment. It's not an application, but I will say to the tribunal.
No. I'm not asking you to argue the default judgment. I'm asking you to tell me, how should I reconcile what you are just saying with what you said earlier? You said earlier you don't want to stop the default judgment proceedings, but you're just alerting this tribunal and presumably your opponents to the fact that an exception has been filed. And if an exception has been filed, what is to happen to this? Are we to enjoy reading it and just simply continue with the default judgment hearing? What is the outcome you're anticipating?
I do anticipate that the tribunal would wish to hear arguments of both sides on the exception at some point.
So we can go ahead and record default judgment today, and then you want to, at some stage, argue the exception.
Well, I would hope that the default judgment would not even be considered at all.
Well, there
but
you
I do
go.
not want to argue it.
Yes,
I would hope so.
Whatever you're articulating as your intention doesn't appear to be the intention that you filed the exception with. And that's my problem, because in effect, this exception that you filed minutes ago is going to scupper the hearing that was set down for default judgment today, which date was then set many months ago. So this is what I'm saying. In effect, what you're going to do is you're going to scupper today's proceedings. We've got to simply put it on hold until everybody considers your exception.
May I please address the tribunal on something else?
Yes.
The last time we appeared before Justice Modiba, I'd said in argument that my instructions are not to engage because the jurisdiction of this tribunal is being challenged in the High Court in two separate proceedings. The affidavit filed by the president himself said we should wait for the judgment in Ledla. In any event, if we are raising issues about jurisdiction, I submitted to Justice Modiba that there is no basis to even be fixing date for default judgment, but the tribunal in its wisdom decided it will hear a default judgment. That's why I'm saying that I do not wish to stop a default judgment from being heard. And I indicated to Justice Modiba that unlike a few other cases, we are fortunate at least that the tribunal has now ruled that we don't need leave to appeal its judgment. And I want to place it again on record that one, the tribunal has no jurisdiction. If it proceeds, we will of course appeal, but we do not want to get into the merits of it. But out of courtesy, I said, let's put an exception on the record because we have two proceedings in the High Court that the SIU itself filed lengthy affidavit where they said we should wait for Ledla's judgment. And maybe I should on that point mention to my lady that on the 1st of August, similar argument was advanced by Tembeka before your leadership that the tribunal cannot, on one hand, say that Ledla must be decided. So it's not engaging with the issues of jurisdiction. And we are then at the same time going through the what would amount with respect, probably a fruthless trial process where evidence will be led when we are all waiting for Ledla. And we have two High Court applications that will deal with the merits of this entire case.
Yes.
So the point, my lady, is that it is not the exception itself that is first raising the question of jurisdiction. It is the two High Court proceedings that against the special tribunal, one filed by the 7th respondent, one filed by the 8th respondent. In one of them, the SIU has not even filed its answering affidavit 6 months after they were served. The question is whether this tribunal should, in good conscience, disregard those processes and then say that we should start preparing for trial when the reasons why we are not proceeding with the High Court applications which were filed months ago is the SIU and the president telling us to wait for Ledla's judgment. So they on one hand are not assisting to finalize the High Court, which should determine the jurisdiction, yet they want us to go into a trial. So hence I decided I will file an exception. The tribunal may well decide to disregard it because we've made these submissions before. It may decide that it wants to, in good faith, ask this SIU itself to respond to those issues. But should the tribunal decide that it will disregard the exception, it will proceed with a default judgment, we of course have a recourse.
Yes. Is there any further submission?
So broadly, my submissions is around those three issues. First, the tribunal presided over by my lady in the SIU and Translate recognized the need to be sensitive to the application before the Constitutional Court. The two applications in the High Court to challenge the jurisdiction of this court that have been stalled by the SIU itself. And thirdly, the issues that we have raised in the exception should be considered as part and parcel of the decision of the tribunal whether it wishes to proceed with the default judgment or not.
Right. Are those your submissions, Mr. Ganrombi?
Yes, my lady.
Thank you. Ms. Williams?
Thank you, my lady. My response to my learned friend is brief. Firstly, he comes here and he submits that he doesn't wish to derail these proceedings. That's exactly what the 7th and 8th respondents are trying to do. Secondly, at 10:29 this morning, another 28-page exception was filed, this time on the part of Ms. Mahoda, the 7th respondent. My learned friend did not even have the courtesy to draw this to the court's attention. Thirdly, Mr. Ogun Ruby is...
Just give me a minute. Sorry, give me a minute. Yes.
Mr. Ogun Ruby is completely mistaken on his reading of the rules of the special tribunal. Rule 13.1 says in terms that action proceeding shall be commenced by issuing out a summons and informing the defendants inter alia that if he or she disputes the claim and wishes to defend same, he or she shall within 10 days of receipt of the summons deliver their notice of intention to defend together with a plea, with or without a claim in reconvention, and then the important bit, or an exception. So it is extremely misleading to tell the court that exceptions are not regulated in Rule 13, and to say that this is another pleading regulated in Sub-Rule 7. It's regulated in Sub-Rule 1. They're ipso facto barred from pleading. They cannot file an exception today as they purported to do. This, my lady, is extremely abusive of this court's process or the tribunal's process and should not be countenanced. It's the sort of conduct which should attract a punitive cost order. So, if my learned friends have a problem with this court's jurisdiction, then they should have gone to the High Court to try and prevent the court from this tribunal from hearing this matter. They haven't done so. Today I'm sitting and I'm hearing about a second court application. On the 12th of September, there was only one. The court would have noted from the minute that Justice Madiba dealt with the High Court proceedings. In the minute, it's at 050-11.
Just a minute. Is that filed in the bundle here with me?
Yes, it should be, my lady. Paragraph 3 of the minute.
Just give me a moment. I'm trying to get to it. Yes, I found it. Just give me one moment. What paragraph did you say?
On page 11 at paragraph 3. The heading says the proceedings in the High Court under case number 57571/2022. And then 3.1 is the important paragraph. The High Court proceedings are separate and distinct from the proceedings in the Special Tribunal and do not suspend the matter in the Special Tribunal. So it is inappropriate and in fact improper for my learned friend to submit to Her Ladyship that there's an issue with the jurisdiction of the Special Tribunal and that this has now been taken in these proceedings, when in truth and in fact it hasn't. The court would also have noted that Justice Madiba noted the High Court proceedings and ruled that the default judgment application will proceed. And the further conduct of the matter was also regulated at page 13 in paragraph 5.7 of the matter as regards the upliftment of bar. That's because they have been barred and they cannot now seek to have or to be heard before the tribunal unless that bar is uplifted. So we would ask that the matter then proceed to default judgment or that the application proceed on an unopposed basis. Just finally, my learned friend has not produced a single order that says that the Special Tribunal cannot hear this default judgment, firstly. And secondly, the appropriate manner to deal with any default judgment that the court may grant would be to apply for rescission, not to come and try and derail the hearing as they're now trying to do, the 7th and 8th respondents, that is.
Thank you. I'm just going to give you a very, very short time to respond to that, Mr. Ogunrobi. And I'm giving you a hearing, as I say, out of professional courtesy and also in the interest of justice. But very shortly, if you can reply to what Ms. Williams has just said.
I'm indebted to my lady. My lady, just to point out that I would just refer to Rule 13.3 of the rules of the tribunal, where the question of a party being ipso facto bad being referred to in relation only to a plea. That's the first point I want to make. And in amplification of that point, my point is that perhaps I was not as clear that with regard to an exception, a notice of bar will come into play not in respect of an exception, but in respect of a plea. Hence my reference to 13.7, where the rule specifically then said that if any party fails to deliver any other pleading within the time period laid down or within an extended period, any other party may by notice to the other party. We have not received such a notice in respect of an exception. Hence I'm saying that we do not have the same reference to being ipso facto barred from filing an exception. And support for that interpretation will still be found in Rule 14 of the rules of the tribunal, where it affords the parties to obtain agreement on time for filing papers. And what I thought, Martin, is, and I must say that the fact that it was filed as late as this, I'm not aware. I sent out the settled draft as early as 6 a.m. this morning. So I do understand the difficulty of saying that papers were filed at 9 p.m. or 10 p.m. It is not my intention to get into the merits of whatever is filed into the exception, but to inform the tribunal that that is something that is in the process. The second thing that I wish to make reference to, my lady, is perhaps to even say that with reference to the High Court, I can refer the tribunal to a number of authorities, but probably one will suffice. With respect to the fact that when it comes to exception of this sort, we have not been barred from filing that exception. Perhaps even if we look at the commentary in Erasmus on the commentary in relation to Rule 26, I think there are quite a number of cases in footnote 5 which deals with this principle. If the court will, if the tribunal would want me to mention some of those authorities, and I have one open in front of me. But the point is that with regard to exception, we can seek agreement with the other side, and if they choose not to, we can bring an application for that. And lastly, Milady, I still reiterate the fact that it is not my position that the tribunal cannot, if it chooses to grant, entertain the default judgment. I am only said that in light of the 2 court applications before the High Court, which are all known to the SIU, which are all defended by the SIU, and the insistence on the president to say, let's wait for Ledler, it's only reasonable that the tribunal should, not could, should not. If it does, of course, as my learned friend has rightly submitted, we will have a recourse elsewhere. So it's not my intention to preclude the tribunal. I'm only appealing to the tribunal to consider in deciding whether to grant a default judgment, whether these are relevant facts.
How do I then deal with a directive of this tribunal, the president of this tribunal, regarding the upliftment of the bar, regarding the fact that where she noted the High Court proceedings and said it will not suspend these proceedings? Am I to simply ignore that?
With respect, lady, I must say this by reference to what has happened in this tribunal, that I have argued, I've been told by the previous president of the tribunal that we should apply for leave to appeal. We had argued before Justice Mondiba that we did not require leave to appeal in this court. I have 2 other applications in the High Court in Pretoria. Before the court, the tribunal then ruled that it did not itself realize that there's no requirement for leave. My point is that with respect, a procedural directive of this tribunal can be disregarded by the presiding officer if the tribunal is of a view that it does not accord with, it's not a ruling on that requires any appeal or setting aside. So many leave to appeal were refused before this tribunal. We had argued that we didn't require leave. And in this instance, I'm saying, milady, that if an earlier ruling, as in this instance, is evidently erroneous, you are not, my lady is not bound to give effect to an interpretation, when especially my lady in the case of Transnet expressly recognized that Ledler should be awaited, the judgment in Ledler should be awaited before proceeding to the merits of that case. Exactly what is happening, what my lady did in Transnet is what I'm putting before the court right now again. So there's no inconsistency in the work of the tribunal. The consistent part is that when it is convenient, the SIU has said we should wait for Ledler. The president said we should wait for Ledler. Similar thing appears in this instance, my lady.
Right. I mean, we've really wasted almost an hour now on something that should never have actually arisen right now. But I'm just going to give you a chance, Ms. Williams, because it's a point I raised about the directives made at a case management meeting. And I know you didn't address that because I've only raised it now. If you could just address me on that point, please. I can't hear you.
The directives made by Judge Madiba are binding on the parties and has already now addressed the action in the High Court that he doesn't stay the proceedings. I also think it's important that the tribunal bears in mind that Judge Madiba was satisfied that the defendants were ipso facto barred. Once you're barred, you cannot simply file a pleading without obtaining an extension of time for filing by agreement. That was never sought. But in this instance, and in fairness to Mr. Ogunrubi and his clients, the court gave them this timetable to comply with. There was no question of an exception raised at the time. And it is extremely opportunistic now to try and circumvent the directives of Justice Madiba to now file an exception, which is just downright irregular and cannot be entertained by the court. So in short, those rulings are binding upon the parties. They're also binding on the tribunal because that issue has now been disposed of. And despite the invitation extended for the order saying that the tribunal cannot proceed to entertain this matter, notably, not a single order has been produced. So again, I would submit that the court should allow the default judgment application to proceed.
Okay, I'm just going to, I say it's 10 to 11. I'm going to take a very short adjournment just to collect my thoughts on this, and then I'll deliver a ruling maybe in about 15 minutes.
As the tribunal pleases.
Thank you. again. Is everybody on board?
Good morning, Judge.
Good.
Yes, Judge.
Thank you. I am going to deliver a very short ruling, given the fact that I had 15 minutes to apply my mind to this. And in the interest of progress in this matter, I will deliver a very short ruling. I must start off by saying that I am deeply concerned at the manner in which the 7th and 8th respondents have conducted themselves in this manner, in this matter. You know, filing a few minutes before and a few minutes after the hearing started to file an exception is seriously worrying. The rules are there to ensure that there's orderly and fair proceedings in respect of both parties. This amounts to nothing but litigation by ambush, and that is seriously frowned on. And it's well established in our law. There's ample authority for that, right to the level of the SCA, and if I'm not mistaken, the Concord as well. But that kind of conduct simply is not tolerated in the practice of law in this country. And that's what it has amounted to. The 7th and 8th respondents were served with the summons. They did not file a plea, although they were the only respondents to have opposed the matter or filed notices of intention to defend, but did not file their pleas within the time allowed by the rules. A case management meeting was then held on the 12th of September 2022 to further direct the proceedings in this matter, because at that stage the SIU had decided it was going to apply for default judgment. The meeting on the 12th of September 2022 was attended not only by Ms. Williams but by Mr. Ogunrombi as well, on behalf of both the 7th and 8th defendants, instructed by two separate firms of attorneys. And what had happened in that matter, they made submissions, or he made submissions regarding the rules and interpretation of the rules. Ms. Williams responded. So Judge Modiba heard those submissions. And what she found was that after hearing argument, the following ruling was issued by Justice Modiba. 5.7.1, and I'm reading from the case management minute of the 12th of September. The 7th and 8th respondents are directed to bring an application for the upliftment of the bar in accordance with the timetable below. And I'm going to read it just so that we contextualize this. 5.7.2, the application shall be served and filed by 26 September 2022. 5.73, the answering affidavits shall be filed by 10 October 2022. 5.7.4, replying papers shall be served and filed by 17 October 2022. 5.7.5, applicants' heads of argument and practice note shall be served and filed by 21 October 2022. And 5.7.6, respondents' heads shall be served and filed by 28 October 2022. All documents are to be uploaded on case lines. Then further on, the application for default judgment is dealt with. And just before that, on 5.7.8, the tribunal directed that the upliftment of bar, the application for the upliftment of bar, shall be heard on 21 November 2022. And as regards the application for default, answering affidavits shall be filed by 21 October 2022. And so on, the timetable for replying papers as well as heads of argument should be filed. And the final date was 21 November 2022 for the applicant's heads of arguments. And then the tribunal also then held, with regard to the arguments about the High Court proceedings, and that is dealt with at paragraph 3 of the minute. And the heading, as correctly pointed out by Ms. Williams, is that the heading in paragraph 3 is the proceedings in the High Court under case number 7571 of 2022. And this is what the tribunal ruled, 3.1, the High Court proceedings are separate and distinct from the proceedings in the Special Tribunal and do not suspend the matter in the Special Tribunal. 3.2, on 3 June 2022, the plaintiff, who is the first respondent in the High Court case, filed its answering affidavit to the application brought by the 8th defendant hearing, who is the applicant in the High Court case. And in bold, the High Court proceedings were noted. The default judgment application will proceed. So that was decisively dealt with, and it wasn't simply a ruling made out of the air. Clearly, the parties were given an opportunity to address Justice Madiba. She applied her mind to it, and those were the rulings that she made. Now, at the 11th hour today, before the matter proceeded, the tribunal was not privy to those documents, and the SIU's counsel or legal representatives were already seated and ready to start the proceedings when the application or the exception was filed. Mr. Ogunrubi again referred me to Rule 13 in this matter, where he says he is entitled to do that or he is not barred from bringing an exception. That is simply not so. He was barred from entering into, or his clients were barred from entering into the action. They were given ample opportunity, that's 3 months ago, to uplift the bar. Mr. Ogunrubi was present at that case management meeting, and there's absolutely no indication as to why that was not done. But simply at the 99.9, we get an exception. That is just simply improper. It is definitely an abuse of the court process. And in light of what has been ruled in the case management meeting, which both parties consider, or all parties consider themselves bound by, this tribunal's hands are tied as far as that is concerned. It doesn't avail the respondents to come now and say that the jurisdiction of this tribunal is being challenged, and because it's being challenged in other high court matters, the same should follow here. It doesn't work like that. They submitted to the jurisdiction of this court. Pleadings were closed, so to speak, and the further process in terms of the rules must unfold. It is simply impermissible for parties to show such flagrant disregard, not only for the rules, but the rulings of a tribunal which, by their conduct, they have indicated that they are bound by. So I find it extremely worrying when parties behave this way. It's nothing but opportunistic. And as Ms. Williams correctly pointed out, the hearing today is scheduled with ample notice to all parties who knew that it was going to proceed today, and it will proceed. If the 7th and 8th respondents are not happy with that, then there's further recourse for them, as conceded by Mr. Ogunrubi, in terms of the rules where they can take the matter forward. Just to deal briefly with the High Court applications, the Transnet matter that was before me had different circumstances. And in that matter, it was the SIU who was in agreement with Transnet's legal representatives that they should wait for the matter. And in view of the agreement and the submissions made at that hearing, the court reluctantly then agreed to stay those proceedings until the High Court and the Concourt matters were decided. The circumstances are very different here. That issue of the application in the High Court has been dealt with by this tribunal, albeit at a case management meeting. And therefore, it is not correct to say that this tribunal can disregard that and simply proceed. Because to start off with, that exception or those exceptions are not properly before this court in any event. Having been barred, my view is that the 7th and 8th respondents do not have locus standi to bring the exception unless they now bring a substantive application they should have brought substantive application for the upliftment of the bar, which they have not done and have not tendered an explanation for that. That being so, I am not inclined to suspend these proceedings, and I'm not inclined to even entertain the exception because I believe it's an irregular proceeding and it's impermissible in terms of the rules. I'm therefore ruling that the default judgment hearing will continue today. And with regard to costs, Ms. Williams has submitted that this is an abuse of process and a punitive order for costs should be made. I am in agreement. The 7th and 8th respondents are directed to pay the costs of the SIU on an attorney and client scale.
May I just clarify, Milady? The application, the cost will be in relation to what exactly? Because
filing of the exception, if any. If there's cost in the filing of the exception, then that will be paid for by the 7th and 8th respondent with on a punitive scale, because you have now filed it, they've had to consider it, and whatever costs they are able to prove will be paid by the 7th and 8th respondents.
As the tribunal pleases. May I, on that, I'm indebted, may I then be excused from the...
Yes, certainly, Mr. Ogunrobi.
As the tribunal pleases. Thank you.
As the court pleases.
Thank you. Ms. Williams.
Lady, for purposes of the default judgment application, the tribunal should have received the SIU's heads of argument.
I did.
We also filed, thank you. We also filed a practice note, and then there's a draft order. Yes. Essentially.
Yes, sorry, you may continue.
Essentially, the heads of argument address the background to the matter, starting with the acquisition of the Nirvanda farm, the registration of the Big 5 CC, and the various claims and how they arose. I think it's probably...
Yeah, you've set it out very comprehensively, and I've also read the papers, so I'm fully acquainted with the history and so on. In principle, there are certain of the claims which I have no problem with granting default judgment for, but I have some queries, and I'm quite sure you'll be able to clear up my concerns. And well, claim A has been abandoned. With regard to claim B, I've read the expert's report, and one can understand the situation he finds himself in, because there are so many variables. You know, when you're dealing with matters of the soil, there are just far too many variables. And my concern is that he gives a figure, you know, somewhere between 42.104 million and 50 million as the cost of rehabilitating and getting this farm back into a functional state. I see that this SIU has kind of gone the middle road and say, okay, 45 million, but can I make an order for 45 million if it is not a properly liquidated amount? That's just my concern. If I'm going to do that, should we not put a rider to it, or should we not grant it, but have a rider where, you know, at some stage, you will then be able to substantiate the quantum? But let me hear you on that.
Milady, when I went through Mr. van Rensburg's report, I had similar concerns about the amount that were being claimed because of the assumptions underpinning his report. And for that reason, I am entirely with the tribunal on the claim for 45 million. It could be 42.
Or it could be 50.
Or it could be 50. And for these reasons, the one thought that crossed my mind was to try and pinpoint or get a more accurate picture, but I understand that that is the best that could be done in the circumstances. So therefore, the courts or the tribunals, your ladyship's suggestion or proposal that there should be a rider upon it is something which I certainly, on behalf of the tribunal, would support. And I would
pretty much like we would do in a personal injury claim. We would say the defendant is directed to pay the plaintiff's such of the plaintiff's damages as it is able to prove. Something in that nature, so that you don't sell yourself short and you're not unfair to the defendant.
That's correct, my lady, and we would support an order as your ladyship has suggested, because I think that is fair to everyone involved in this matter. So insofar as Claim B is then concerned, it should simply record payment of the damages as the SIU may prove or as may be agreed between the parties. My lady, we will send the court a revised draft order.
Right. Well, let's continue. I have a few more queries, and as I said, I'm quite sure you'll be able to resolve them. Claim C, I'm fine with that. That's less than the initial amount claimed because you now have documentation. Claim D, the forensic report as well, I think was initially an approval for 2.9, but you're claiming 2.6, and I've seen the documentation. Claim E, I'm a little concerned about. I've seen the schedule for the legal fees, but I don't see any proof of payment. Is there proof of payment of these fees? I mean, saying that this is what our legal fees are, but have we paid them is another story.
Lady, I'd be very surprised if the council had incurred these fees and have not been paid.
Yes, so would I, but I still need to know. Stranger things have happened.
I just want to, the affidavit, I think, does deal with the payment of the amounts. It's
they say they've paid, and it's just that when you look at the utilities or when you look at the forensic report, those vouchers are there, so it's plain to see. You've supported your claim, and I'm not saying this is not accurate, but just simply a schedule without some approval for payment or some receipt or something like that, it might be a little bit. I just want to see those documents, but which I'm sure is easily obtainable.
Yes, these would all have been Department of Justice payments. It would have have gone through the BASD system, and there should be proof of those amounts having been paid. I can't. They haven't been appended to the affidavits, and under those circumstances, we could do one or two things. The court could either grant the order subject to an affidavit being filed annexing proof of payment. Alternatively, to postpone the relief sought under that clause pending the lodgement of proof of payment with the court.
Well, we could do that. We'll think about that. Let me just raise the other concerns that I have. Initially, you said that the seventh respondent acted unlawfully in giving the instruction that should Big Five indicate that they're available or want to, then they should be appointed as the reform beneficiaries. It's not very clearly set out. I don't know if it appears from the reams of documents that you've attached, and I'm sure it must be, but what is the basis to say that it is unlawful? Why is it unlawful?
For a variety of reasons. Firstly, There was a process to identify land beneficiaries. There were 15
Yes, I see that.
beneficiaries in the
And-
running. Big Five was not among them. Big Five was looking to get the Wiederum farm, but there was a problem with the purchase of that farm. There were delays, and I think that the sale didn't proceed. And Big Five then complained to the minister, who raised the issue with Ms. Magoda, and it was then decided that they should get the Navanda farm. A couple of problems with that. There's a process that must get followed before a successful applicant is identified or a beneficiary is identified.
Which process was underway and got scuppered?
It got scuppered insofar as the 15 were concerned, and the farm was then just given to them. Other problems surrounding that, milady, relates to the fact that the first caretaker agreement was dated December 2012. Big Five wasn't even registered on that date. So Ms. Magoda had no right, no authority, no entitlement to simply give the farm to Big Five, which is what happened here.
And then just allied to that, the fact that there was a second caretaker agreement for a period after actually appointed beneficiaries. They were appointed beneficiaries on the 25th of July,
Right.
but the second beyond that period.
That's correct. A caretaker agreement is something which is sparingly used. You
Well, it
can't
is stated so in the policy in any event.
Yes,
that
that's
it was
correct.
sparing, yes.
So you can't just appoint a caretaker, but in addition to the unlawful appointment after the allocation as a beneficiary, we also have a situation where a farm, it's being eroded because it's not the farm is not being used as for the purposes intended. So there are a number of problems with this whole process. We haven't found any motivations for these caretaker agreements. The first one was unlawful because they weren't even registered. The second one is unlawful because, as the court correctly points out, they were already now the so-called beneficiaries. The other thing which the court would also have noted is that there was no process for their appointment as beneficiaries. It was a question of them deciding that they would like Nirvanda Farm, and Ms. Magoda then telling them, well, fine, then you can have Nirvanda Farm. And that's what happened here.
Okay. All right. Then it also, with regard to unlawfulness, the 8th defendant's decision to settle. It's not very clear. There's an allegation, I think it's either in the affidavit or the heads, which says that the director or the acting director general, I think it was, did not know. But I'm not seeing that coming out in the papers, save for the allegation. So why was that an unlawful decision?
Well, it was unlawful on several planes, my lady. The first one is that, and I do apologize for this, there are financial delegations in the Department of Rural Development and Land Reform. I understand that it was a requirement that the Director General, or I think they had an acting Director General at the time, should have approved the settlement. That didn't happen.
That is what I'm saying.
It's not before the court.
Yes, if that was simply attached to say why you're saying it was unlawful and refer to, document XYZ, because this is what it says, and that's not what she did. That then the unlawfulness of it becomes obvious, and it's clear to see. At this point, is remembering her position. She's a chief director, and I need to be satisfied that it is in fact an unlawful decision, which resulted in financial implications to the state.
Milady, I do appreciate the court's difficulty, the tribunal's difficulty with that. In fact, this morning, before the hearing, I was trying to find a copy of the delegations. I've been given the first page, and I do recognize the document. I haven't seen the clause that says that the acting Director General must approve a
There must be
settlement.
some sort of process, even if it's an internal policy, or, you get these circulars from time to time in government departments saying with regard to that, this ABC will happen. Even that, to show that there was a decided and a proper process in place, which was not followed by the 8th respondent, so that the unlawfulness of it becomes apparent immediately. Because, that one can't, for instance, go on to the last claim or the last order that is sought to say that it must be, yes, the declaratory order, until I'm satisfied that these are the things that these two officials did, which render those decisions liable to be set aside. So that is the one thing, and I'm sure it's a simple matter of getting these documents, I'm quite sure. So, as I said, in principle, I don't have a problem with authorizing it. It's just a few of these questions that arose, and those are the important ones, because those two bear directly on the declaratory order that is sought. I can't set aside something if I don't know that it is indeed unlawful. So that is the thing. And then there's just other little minor things. If you look at paragraphs 87 and 89 of your particulars of claim, are they not the same thing?
87 and 89.
Yeah, of your particulars of claim.
No, the one is to say that the settlement was unlawful and invalid. 89 says that because it was unlawful and invalid, the plaintiff is entitled to a declarator, that it is invalid.
Okay, so that's basically because of the invalidity, then yes. I've got to declare that you are entitled to the declarator.
And that is why I think it's important that the tribunal has the relevant delegations from which
relevant, yeah,
the unlawfulness appears. And then just also to highlight that the unlawfulness doesn't only flow from the fact that the Director General didn't approve the settlement, it also flows from Ms. the 8th respondent's conduct in this matter. The court will recall that the previous counsel, I think it was Advocates Carnowitz and Allen, they withdrew from this matter because they were not getting instructions. Then, after Ms. Mahoda was dismissed in the as a result of the disciplinary, there was then this process before the bargaining council,
yes,
which we deal with under Claim F. Then 79, the court will see that there was this issue with the lack of instructions, and council then returned their brief.
Yes.
Then in paragraph 81, junior counsel was briefed, apparently due to cost constraints. He too wrote a memo in 82 that the department had strong prospects of success in the arbitration proceedings, in particular on his consultations with the department's key witnesses. From the disciplinary hearing, there were 2 key witnesses for the department, and it was on the basis of their evidence that Advocate Golden SC, who chaired the disciplinary tribunal, found Ms. Magoda guilty on 6 charges.
Yes.
That's in 75.10 of the heads at page 31, and on charges 1 and 5, they were dismissed. There was no merit. So we have these 2 witnesses, but notwithstanding that opinion from counsel, Ms. Satsitswani influenced the department's 2 key witnesses not to testify at the arbitration.
Where is that reflected? You see, that's the other thing. It bothers me that it's a serious allegation, but is there some sort of substantiation for that?
I don't have, sorry, my lady, we don't have. We don't have an affidavit that deals with that. We don't have an affidavit which corroborates that averment.
So,
but,
you know, I mean, if they defended it, I'm sure they would have applied for that to be struck out because it's vexatious or scandalous. And so therefore, that, as I said, is a serious allegation, but I don't see anything in the papers to substantiate that other than what is said in the particulars of claim. So that was a concern for me. And then the other minor thing is annexes P06 and P07. I think it's the settlement agreement and something else that don't appear to be signed, but it may be that I've just got bad copies.
There are P06 and P07 are the arbitration agreement is P08, and the one which is before the court at 218 does not. It seems to have a signature from the State Attorney Pretoria. It does also appear in the affidavits. Shall I just look at your affidavits?
Yeah, it was one of the supporting affidavits was attached to that.
Correct, my lady. Yes. It's the one of Van Rensburg. Yeah.
Yeah, no, that's fine. I'm quite sure they were signed out because I recalled in much later when I read the supporting affidavit. It does look like it was in fact signed. But the note I made was when I was reading the papers, reading the particulars of claim, and I said, but this doesn't look like it's signed. But then I realized it might have been a bad copy.
It's the signed version. Your ladyship will see at the section 004-68.
Yes, that's right. Yeah, and that's why I said I was happy that it was, and that's why I concluded it was just a bad copy that I had. Yes, so that's fine. That's taken care of. What else? So, as I said, in essence, these are the things perhaps that you can gather these documents, which, as I say, I don't think will be too difficult. What is the position with regard to the fifth defendant now? Because I see you have served him.
Milady, at the time that we commenced with the default judgment application, the fifth defendant had, I think, just been served, but the DAs had not expired against the fifth defendant. They have now expired, and there would be no reason why we can't give the fifth defendant notice that the matter is proceeding against him.
Yeah, so well, that's obviously up to you. It shouldn't really affect the hearing here. But these documents, in regard to claim B, claim E, and then the delegations, as you were talking about, in respect of the seventh and eighth defendants, just to clarify and to make it clear that those decisions and actions on their part were in fact unlawful, because it then will bear directly on claim F.
That's correct, my lady. So, insofar as claim B is concerned, I had, in light of the tribunal's issues with it, I'm in agreement with your ladyship that that claim should be formulated to read payment of the amount bond due, or as may be agreed between the parties, although I think the latter can probably safely be omitted. Insofar as claim E is concerned, that is the legal expenses. I would submit that the court could grant that subject to filing of the proof of payment.
Let me ask you this. Are you available Wednesday morning?
Yes, my lady, I am.
Because then what I would propose is let's just roll this over until Wednesday. Then you can gather all of these documents and do me an amended draft order. Then it will just be a few minutes. You can circulate it to me or have it emailed to me beforehand. And it'll just be a few minutes for us to consider and for me to grant the order. I'm quite happy to do that.
I'm indebted to your ladyship for standing the matter down until Wednesday.
Yes, I will be able to probably around 10. I have a meeting in the morning, but I will be done by 9:30. So, yeah, we could easily meet at 10 o'clock.
Thank you, my lady, whenever it's convenient to the court.
Yes, all right. So I think that would be, as I said, I've given you my prima facie view. In principle, I don't have a problem with granting it, but I think I need to be absolutely sure that the orders I make are proper orders. So, and these documents that we're discussing would be very relevant to that. So let's just rather do that. Let's postpone the matter until Wednesday morning and for you to get all of these documents and an amended draft order together.
We'll get everything to the court by tomorrow if that's in order.
Yes, that's fine.
Thank you, my
Thank
lady.
you so much. The matter stands adjourned then until the 30th of November 2022. Thank you.
The court,
Okay,
please.
we'll take the adjournment now.
Thank you.